Hello, good afternoon, everybody. Almost. It's half an hour till the afternoon. I'm doing a presentation about school exclusion in a time of coronavirus, now that everyone is potentially going back to school at some point this year. I'm just going to share my screen so that you can see this presentation, and then I'm going to play it as well. How do we do that? From the beginning. Right. So I think that has worked. Conference host has put his thumbs up. Fantastic. Right, so I'm going to talk about school exclusion in a time of coronavirus. And I'm going to look first at what the normal position is when it comes to school exclusions. And I call that the pre-COVID-19 scenario. And the revised position that has been released a couple of days ago is on the 29th of May, where the government released new guidance on how to deal with school exclusions, which makes sense because more children are going to be in a school environment. And lastly, because I know that Hayley has had a number of questions about what happens if I don't want to return my child to school. Is there any risk that my child might actually be excluded from that school if I don't send them there? So those are the things that I'm going to talk about. The main document that you would be looking at if you have a child who's in a maintained school or a pupil referral unit or an academy school, and academy schools includes free schools, studio schools, and alternative provision academies. You'd be looking at this document on the left-hand side, which is the statutory guidance from the Department for Education to deal with the legal responsibilities that come up on schools and governing bodies in relation to school exclusions. So it's really a document that head teachers and school governors should be very familiar with. And also, if you have a child who may be having issues that mean that they have been faced with exclusion before, or they have been told that they are at risk of exclusion, it's a really useful document to have at your fingertips and have a read of. It doesn't apply to schools that are private independent schools, and I'll come to that in a second, but it will apply to most cases I think that we are we'll be looking at. So when you have a decision to exclude a pupil and you're the head teacher, you've got to make sure that it is these three things: that it's a reasonable decision to exclude them, that it's a lawful decision to exclude them, and that it's a fair decision to exclude them. And I can go into a lot more detail about what all of those things mean, but we don't have a lot of time, and I want to focus on the coronavirus position. But effectively, lawful, for the purposes of most parents, perhaps even all parents here, is really about making sure that that decision is one that is complying with the law around the Equality Act, complying with the law as it might surround exclusions themselves. So it's a lawful reason to exclude, so not because of academic reasons, but to do with a breach of the school's behavioural policy. So it has to be lawful and fair and reasonable. And with that in mind, if parents dispute that the decision of the head teacher was wrong, they can then go to the governing board, and the governing board has got to look at all exclusions, permanent exclusions that take place in a school, and other types of exclusions that are of a certain length. And if parents dispute that, they can then argue that the decision needs to be reviewed by something called an independent review panel. And if there's another allegation of discrimination, that can be raised at the independent review panel, but it is also really, in my view, much better dealt with in the first tier tribunal. And that's a forum that I imagine that many of you are familiar with, that deals with the content of EHC plans, but also deals with disability discrimination and has a fast track procedure for discriminatory exclusions, particularly if it's a permanent exclusion. For other types of discrimination, so your child's been excluded on the basis of their race or their sex or something like that, the county court is the place to go. So as I said, independent schools and independent special schools are not covered by the statutory guidance. Those sorts of exclusions are dealt with by contract law. Because of that, you'll need to be looking at the school's terms and conditions. And if you do have this type of issue, it's probably best to look and get some specialist legal advice from a contractual perspective as well, because those helpful principles that I heard about mentioned before from the statutory guidance are less central, although they can inform the process. But all schools are bound by the Equality Act. So no matter what type of school it is, your child can't be excluded for discriminatory reasons. And that's a very short way of putting it. I'm sure there'll be another talk at some point about discriminatory exclusions in themselves, but that is the headline point I want to emphasize. So what has been released on the 29th of May was new statutory guidance called Changes to the School Exclusion Process during the coronavirus COVID-19 outbreak. So the Department of Education has got the power to release further statutory guidance under regulations that relate to school exclusions themselves. So it's quite a statutory process, but this is what they have created in order to deal with the fact that many schools are not operating fully, that parents might not be able to access meetings, all of those sorts of things. And my reading of it is that it looks fairly fair. It doesn't seem to have anything that's a zinger from a public law point of view. So I'm not too concerned about it in itself. So what I'm going to do in this section is go through what it actually says so that you can be familiar with it if your child does face an exclusion during now and September. So the main point is that guidance that I was just talking about, that it should be fair, reasonable, a lawful exclusion, still applies. So those normal arrangements that follow, that are detailed in the statutory guidance, are still really important. They still have to be complied with, and include all sorts of things about a school being aware of the reasons why a child might be acting in a certain way, looking for early intervention, looking for assistance from experts, trying to work out ways to avoid excluding a child with an EHC plan, because that's meant to be a last resort. All of those things, those normal arrangements, still apply. But apart from two key areas that start from now, those two areas are timing and remote access arrangements. So things that actually seem to me to be quite understandable and predictable in the current world that we live in. So in terms of how long these new arrangements last, they started on the 1st of June, and they'll apply to all exclusions that occur from that point until the 24th of September 2020, so include those dates. Those arrangements apply to permanent exclusions and fixed term exclusions that have occurred before the 1st of June, which have not yet been considered by the governing board of the school. I've put that in italics because some of you may have had fixed term exclusions or even permanent exclusions that haven't properly been dealt with during the lockdown. And if they haven't yet been dealt with fully, then you'll need to be using this process. So for example, if there hasn't been a governing board meeting, these new arrangements would have to apply even if the exclusion was before, notwithstanding the fact that that delay is probably in itself unlawful. And then for permanent exclusions that have occurred before that point, if they then choose to consider it, so if the governing board has looked at it and they've chosen not to reinstate the pupil, and the time limit to apply for a review decision has not passed. So that means the review is the independent review. So if there had been a governing board decision before 1st of June, but there's still time, so I don't know, say for example, the governing board decided 2 weeks ago to exclude, you're now in that period, then the IRP process is now covered by this new arrangement. That makes sense? So that's where that timing comes in. And then in the same way, this seems to be a repeat of the first one, but permanent exclusions occurring before 1st of June, where there hasn't been a governing board decision review and hasn't yet happened, again, these arrangements apply. And they will continue to be subject to these arrangements until 2020. And any exclusions that have not finished, so say you have a permanent exclusion on the 24th 20th of September or a governing board meeting around that time, and then that hasn't then finished, then that process is still covered by the arrangements. And by that I mean the timing and the remote access arrangements. Possibly the remote access arrangements won't be needed by that point, we hope. So if you do have an exclusion during that time, an exclusion needs to have be taken as having occurred on that first day of an exclusion, not the date on the letter or the date that the head teacher calls you up and says it happened. So it needs to be that first day that that child is told not to go into school. That's when you take that timing. And then, so that's important in terms of timing. When you're looking at remote access arrangements, the remote access arrangements are quite a key part of the new guidance. So governing boards and independent review panels have got to meet to consider an exclusion. That's the legal requirement, particularly of a governing board. And then they can do that via telephone or by video conference software, so long as certain conditions are met. So if any of you have had Zoom hearings already via to deal with first tier tribunals, it has that sort of thing in mind. But it's really important that these conditions are met, and the responsibility for those conditions, I'll tell you in a second, is with the governing body. They have to do that. It's not your responsibility to secure this. So it has to be not reasonably practical for the meeting to take place in person within the usual timescales because of coronavirus. And the governing body or the arranging authority, like the local authority of the meetings in IRP, is satisfied that everyone agrees to using remote access, that everyone has access to that technology, which will allow them to hear and speak throughout the meeting, and to be to see and be seen if a live link video is used, that everyone will be able to put across their point of view or fulfill their function, and that their meeting can be held fairly and transparently through remote access. So that's really important because of that triangle that I showed you earlier, to make sure that these exclusions are fair. That's probably the key aspect to have in mind when you're looking at this particular principle. And as I said, whose responsibility is that? Is the governing boards or the IRP, the person who's organising the IRP, the local authority. And they have to make sure that those conditions are met before a meeting takes place. And they do that by assessing the case, the circumstances in which a meeting in person could be expected to take place, the needs of those intended participants, as far as is possible, and the latest public health guidance. So there's some flexibility in this about whether or not there might be, another wave or something like that. It seems to be giving that flexibility to governing boards or local authorities here. And determining whether it would be reasonably practicable to meet in person. Some of you will have your own needs as parents that are also important to bear in mind by way of your own protection under the Equality Act. And it's fair to say that this doesn't say it explicitly, but the guidance does say explicitly that reasonable adjustments are made for participants in making sure that they can attend that particular meeting. And then you then have a duty to explain that technology. So obviously, for those of you who are on the Zoom call, you managed to get onto the Zoom call, but it has to be really important that pupils and anyone who needs to or wants to get on board and do so has had that explained to them properly, in order to make sure that there is procedural fairness in the review process. And if they are making it difficult for you to access the meeting, then you go back to this new guidance and explain how it is that they aren't actually arranging this and explaining the technology to you fully, and so on. Then, and this is further sort of guidance from the Department of Education about making sure that that preference is adhered to unless there's a clear reason not to. It's quite a lot of flexibility in this, but also quite a clear duty here to accommodate those preferences. so long as the conditions for remote access meeting are met, it's possible for some of those participants to be present in person. So you might have, for example, the school, the governing panel may be all in one place with whatever social distancing rules are applicable at that time. And the others can have access to technology. So you can have a hybrid setup. So same way that we've had some first tier tribunal cases where parents are together in one room, the panel might be 1 or 2 people in the room. I've had, and some school teachers in another cluster. That's also possible as well. So you can have a kind of hybrid approach there. It allows for that flexibility. And as I said, there is absolutely this duty to comply with the Equality Act, both for that pupil, but also for those who might be participating in that meeting, if they might have a disability or if they have English as a second language or something like that. And then, as I said, keep repeating it, but have to make sure that the meeting is conducted fairly. Say somebody drops out halfway through, they have the ability to adjourn that meeting. The guidance already has some ability within it to adjourn, but actually this makes it a bit more flexible for governing bodies to be able to do that without being as worried about the time limits, in my view. Really importantly for probably all of you is that you're still entitled to an SEN expert. So in the statutory guidance that I referred to before, you can have a specialist special educational needs expert who is able to advise the review panel about, or the governing body, sorry, the independent review panel, not the governing body, the independent review panel about what role a child's special educational needs might have played in the exclusion. They're not able to do an assessment. They can be quite objective. They don't necessarily talk too subjectively. It can really range what SEN experts are like. They can be really useful at saying SEN wasn't properly considered, or that this was a child in distress. I'm surprised that there wasn't this expert involved. Or they might say, actually, in my view, the school has done the kind of things I would normally expect in this type of setting. So they don't necessarily act for you, they're there to advise the panel, but in my experience they are quite helpful at spotting special educational needs issues that schools might not have spotted. So particularly given that local authorities or academy trust have to appoint them and cover the cost, it's often worth considering at the independent review panel if you're looking to have that decision of the governing body reviewed. That's separate from if you want to have an expert at the first tier tribunal who will be able to more speak on your behalf and with your views in mind. But it's really important that the IRP process, independent review process through the local authority or academy trust, you can have an SEN expert, and you're also still entitled, as you were before, to have a friend or a legal representative at that hearing. The law does not allow for paper-based meetings. You can have that in for your EHC plan appeals sometimes, but really, because the law doesn't allow for it, these governing board meetings and the IRPs have got to be considered in person. You can look at the written representations. Very commonly, if you have lawyers, you might have a written representation, or you as parents might draft those yourself. But it's important that if a school is saying to you, we can just decide this on the papers, that's not a lawful way forward. And it comes from the principle that the governing board and the IRP are playing a scrutinising role over that head teacher's decision to make sure that that decision is made in line with public law principles. So timescales have been extended, so there's more time now for reasons related to coronavirus to be able to have meetings. They can take longer. You can also have more flexibility about when that meeting is held, as I said. So overdue meetings can take place, all those sorts of things. So a lot more flexibility to minimise uncertainty for pupils and their families as far as possible. And then keep clicking. And then there is, because we've only got about 9 more minutes, there are some tricky points when it comes to fixed period exclusions, but basically this is the point. normally a governing board has got to meet face to face within 15 school days. So that really means 3 weeks. But now the limit is 25 school days, so 5 weeks. So you've got the governing body effectively has more time to deal with and think about reviewing permanent exclusions and fixed period exclusion, fixed term exclusions that are longer than 15 school days. So governing bodies basically have more time to be able to deal with that issue. And in a similar way, the requirement is the governing board should meet to discuss reinstatement if there's a exclusion between 6 and 15 days within 50 school days, which may not really be worthwhile. But if you have a child who has quite a lot of fixed period exclusions over and over, it can be worth getting that exclusion reviewed by the governing body to see, what's going on. Why is this child repeatedly being excluded for multiple periods? So applications for independent reviews, you'll be looking at 25 school days from the date on which notice in writing of that decision from the governing board is given. So that means if you want to appeal to the IRP, you would be given 25 school days, so 5 weeks, but effectively to be able to decide it. And schools have to wait for that period to expire before they can legally remove your child from the school register. So, and that's pursuant to those regulations, the 2006 regulations I put down the bottom. And then, so this is again about the IRP. They also have a greater amount of time to be able to consider. And I think this is really for practical reasons, the school exclusion. This is what I was saying before about the time limits and it being 1st of June. So there's a repeat of what we were saying before. But I also know that there's a key question for many of you about, well, what if I don't want my child to return to school? What if I think actually they might be safer at home? And, there are a number of different headlines that we have seen. There's a quote there from the Telegraph about, I as a parent might think, I don't really feel like it's safe for my child at the moment, given that I'm not really sure what's going on with his or her EHC plan, given that social care has dropped off, whatever, that you don't feel safe returning your child to school. You're not the only person feeling like that at the moment. Plenty of parents feel like that. And also we're seeing only some year groups going back at the moment, and some lack of clarity about, what will happen in England compared to Wales. I've just popped in that the Education Ministry in Wales, I think yesterday, said that all age groups would return to school at the end of June in small groups and staggered starts. That's not the case in England. We have only got at the moment the reception in year 1 plus year 6 model, and a vague hope that you might have children who are 16 or so maybe having a couple of weeks at the end of this term. I don't think that's very likely, but we'll see. So if you don't want your child to return to school, the government has made it really, really, really clear that you will not be penalised for non-attendance at this time. They say we strongly encourage you, if you're eligible, to attend. So unless you're sort of self-isolating or you have health issues, that your child should be there, but they are not penalising you. That's been made really clear by the government, and that's a really clear expectation for you to know about. And they've said it legally that under the new Coronavirus Act, they've actually just applied the law, which would normally could find you guilty of failing to attend the school that they're registered at under part of the Education Act. And again, explicitly, the government have said parents will not be penalised if their child does not attend school. That may change, but at the moment, that is very much clearly what the government is saying. And indeed, the guidance for attendance recording for educational settings has evolved too because of coronavirus, and it says that where a pupil does not attend school and despite being eligible, the code that's being used is code C, i.e. a leave of absence authorised by the school. So they're not putting in the school should not be putting in unauthorised absence, even if the child is eligible to return. I hope that makes sense. But so schools have to do this attendance register. And I think really that's for data collection, and so the Department of Education can see, how many children are being in school, so the school can manage it. But it's very clear what the expectation of parents is. There's a little bit here about the legal route. So pupils can only be removed from the school roll for a particular number of reasons. So this is the part, they can only be deleted from the admissions register, you know, for particular reasons. And you know, it might be because they have moved to another school or whatever. But they can't do it because the child has been away for a longer period and there's unavoidable cause. I've just put up there. So again, that's another thing that insulates you as well. So yeah, so that should be a very whistle-stop tour through school exclusions. And I'm sure that there have been some questions during that time. My ability to look at more than one thing at once is more limited. So I'll have a look at all the questions now that relate to this topic, and I'll see if I can answer those that are still open as well. But thank you very much for coming.